Does anyone here have a court case today? Okay, the gentleman over here on the right, what's your name?
Edwin
Say it again.
Sanchez. Edwin Sanchez.
He's got an interpreter, Judge.
Yeah. Okay. Have the interpreter yet. Okay. And you're just with them to help, right?
Ma'am?
You're here to help him?
Yes.
Okay. And what is your name?
Kate Backard,
Spell your last name.
Backard.
There you go. You have Mr. Malaro. Okay, you guys are set for 8:30, so it'll just be a minute. All right, James H., why don't you take your hat off?
I'm sorry.
Okay,
Hi, Judge.
and you are James Hall,
Yes.
and Mr. Murphy is your attorney, so I'm gonna change your screen name. And then when Mr. Murphy gets here, I will bring you back in, okay?
Sounds good.
All right, thank you,
Thank you.
and I'm having it in the waiting room. All right, do not have Mr. Glazier yet. Good morning, Miss Reinhold. How are you today?
Good morning. Thank you. I'm fine. How are you?
I am good. I am good. So I'm going to go ahead and swear you in now. I do have Mr. Sanchez, but his attorney's not here yet. So I'm just going to swear you in now. So we're set to go. Okay.
Okay, thank you.
Raise your right hand. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications?
I do.
All right, excellent. Thank you. I am just hang out with us for a minute. I'm just waiting on his attorney to appear. Okay.
Thank you.
And it looks like he just appeared. So let me bring him in. Miss Underwood, let me take care of this one first so that the interpreter can be on her way, okay?
Thank you, Your Honor.
All right, Mr. Glazier, I am ready on Mr. Sanchez.
Okay.
Mr. Sanchez can come up to the podium.
Acérquese al podio, señor Sánchez.
All right, this is in the matter of the people of the state of Michigan versus Edwin Sanchez.
Mire, este es el caso de la Fiscalía del Estado de Michigan en contra del señor Sánchez.
I have attorney John Glazier appearing on behalf of Mr. Sanchez.
Aquí tengo al señor John Glazier que comparece en representación del señor Sánchez.
And Isaac Sneed appearing on behalf of the people.
Y necesito la comparecencia en nombre de la Fiscalía.
This is the date and time set for arraignment in this matter.
Esta es la fecha y hora programados para lectura de cargos, para que usted se entere oficialmente de cuáles son sus cargos.
Mr. Glazier, and of course, pause for the interpreter. How would you like to proceed today?
Y señor Glazier, y por favor pause para el intérprete. ¿Cómo quiere proceder usted en el día de hoy?
Bueno,
Mr. Glazier,
Yeah, Your Honor, he is going to plead to, and I guess at some point you have to get amended information, but he's going to plead to attempted CCW with the understanding or with a Killebrew to 1
hold on,
year.
Mr. Glazier, you have to kind of break it down a little bit.
Mire,
So
él se va a
pause there for a minute.
él se va a declarar culpable a CCW con el entendimiento
Okay, I'm gonna pause for a minute to get a Spanish advice of rights.
voy a pausar un minuto para buscar la notificación de los derechos en español. And this is the interpreter, Your Honor. If I may, I have a question.
Yes,
Yeah, Mr. Glacier said CCW. That stands for carrying.
carrying a concealed weapon.
Okay, thank you.
So hold on 1 second.
Segundito.
C 291. Let's see. Un momento. Shouldn't be this hard to find this.
Sí.
Um,
Tengo dificultad encontrándolo.
DC. We're required to have this under the new law, and I should have been more prepared than this. So,
Bajo la ley nueva, nos exigen que tengamos esto disponible, o sea que debía haber estado más preparada.
right, we are handing down to him an advice of rights in Spanish.
Mire, le están entregando a usted la notificación de sus derechos en español.
I'm going to go over them with you now.
Y yo lo voy a revisar eso con usted ahora.
And then when we're done, if you could just sign that.
Cuando hayamos terminado, usted puede firmarlo. Yes.
All right, let me get my script up for Ms. Reinhold.
So, voy a poner mi guión para que la señora Reinhold lo pueda ver.
So I'm going to share my script. Can you see it, Ms. Reinhold?
Yes, I can. Voy a compartir mi
Okay.
mi guión.
Mr. Glazier, so the plea offer is to plead to one count of carrying a concealed weapon, which carries a maximum penalty of up to 5 years in prison.
Mire, señor
That's-
Glazier, el acuerdo es que se declare culpable al cargo de haber llevado un arma oculta, y ese es un delito punible con un máximo de 5 años en cárcel.
But
that's
I
an-
misspoke. It's an attempted, is that correct?
That's correct, Your Honor.
Sí, pero va a ser un intento de, correcto, así es.
So that will carry a maximum penalty of up to 2.5 years in prison.
Entonces, la pena máxima de eso son hasta 2 años y medio en cárcel.
Is there any type of sentencing agreement?
Yes, there is.
¿Llegaron a algún acuerdo de sentencia? Sí, así es.
You ready for it? It's
Yes, sir.
It's a 1-year delayed sentence with no upfront jail.
Si va a ser una sentencia retrasada de 1 año, sin tener que pasar tiempo en el cárcel inicialmente o en prisión inicialmente.
Mr. Sneed, is that a correct recitation of the plea?
Y señor Sneed, ¿eso es lo que usted entiende que esa declaración está correcta? De acuerdo.
Yes, it is, Your Honor.
Sí,
Okay, very good. All right. First, Mr. Glazier, do you wish to have the information read to your client, or do you waive the reading of the felony information? Go ahead, Ms.
mire, en primer lugar, señor Glazier, ¿usted renuncia al derecho de que le lean la información a su cliente o usted quiere que se la lean?
We'd waive that, Your Honor.
Si vamos a renunciar al
Alright.
derecho, señoría.
This might be a minute. All right. Okay, so, Mr. Sanchez, can you raise your right hand?
Señor Sánchez, ¿usted puede levantar su mano derecha, por favor?
And I'm right here, ma'am, but I haven't started on the script yet. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Pero usted jura y afirma solemnemente que usted va a decir la verdad, toda la verdad y nada más que la verdad.
Sí,
Ya.
So you are Edwin Sanchez.
Usted es Edwin Sánchez.
sí,
Yes.
You have heard, and I'm right here on number 2, ma'am, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 2 attempted carrying a concealed weapon?
Mire, usted escuchó a la declaración de su abogado y del abogado fiscal. ¿Es su intención declararse culpable al cargo número 2 de haber intentado llevar un arma oculta?
sí, la hablé con mi abogado.
¿No?
Sí,
Yes.
Are you satisfied with your attorney and the advice that he has given you?
¿Usted está satisfecho con su abogado y la asesoría que él le dio?
sí,
Yes.
Do you understand the maximum penalty for this offense could be up to 2.5 years in prison?
Sí. ¿Usted entiende que la pena máxima por este delito pudiera ser hasta 2 años y medio en cárcel?
sí. sí,
Yes.
But there is an agreement that there would be no upfront jail.
Sí, pero hubo un acuerdo que inicialmente usted no tendría que pasar ningún tiempo en cárcel.
okay,
Okay.
I'm going to number 5. So neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court.
Mire, ni el abogado fiscal, ni el acusado, ni tampoco a nadie en nombre del acusado conversó sobre una posible sentencia con la corte. ¿Es
Is
correcto?
that correct, Mr. Glazier?
¿Es
That's
correcto,
correct,
su
Your Honor.
señoría? Sí, es correcto, su señoría.
Is that correct, Mr. Sneed?
Sí.
Y eso es correcto también.
Is that correct, Mr. Sanchez?
Y es correcto eso, señor Sánchez.
okay,
All right, and we're moving on to number 6. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy, I'm going to go through the whole one and then you can just read it.
Okay, thank you.
You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. So 6 down to the bottom of the page.
En caso de que se acepte la declaración de culpabilidad, no habrá ningún juicio. Esto quiere decir que usted renuncia a su derecho de que usted de haber tenido un juicio, si usted hubiera querido eso. Ahora yo le voy a explicar esos derechos para que usted ahora esté seguro de que usted lo entiende. Usted tiene derecho a tener un juicio público expedito con un jurado. Usted puede pedir que usted prefiere un juicio sin jurado y el fiscal y la corte tienen que estar de acuerdo. Usted también tiene derecho a tener un juicio sin jurado. Usted tiene derecho a que lo presuman inocente hasta que se compruebe que usted es culpable, fuera de toda duda razonable. Usted tiene el derecho a que el abogado fiscal pruebe fuera de toda duda razonable que usted es culpable y usted no tiene que probar nada. Usted tiene el derecho a estar presente en su juicio y a que hayan testigos en su contra que comparezcan en su juicio y a que le hagan pregunta a esos testigos.
I'm going to move up to the next page on the right. You have the, I'm going to read through M or through I, okay, or L, okay?
Mm-hmm.
So you have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310, between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. So if you can read F through L, ma'am.
Okay. Usted tiene derecho a que haya una orden de la corte donde cualquier testigo que usted quiera para su defensa tenga que comparecer en la corte. Usted tiene derecho a permanecer en silencio durante su juicio y a que su silencio no sea utilizado en su contra. Sin embargo, usted también tiene el derecho a testificar en su juicio si usted quiere testificar. usted entiende que si usted hace su declaración y su declaración se acepta, usted es posible que esté renunciando al derecho de apelar asuntos que pudieran, de lo contrario, a ser apelables en caso de que usted fuera condenado en su juicio. Usted entiende que cualquier apelación de la condena o sentencia, de acuerdo a su declaración, será por aplicación para abandonar una apelación y no por derecho. Usted entiende que si su declaración se acepta y usted comete algún mal comportamiento, tal como se define en MCR 6.310, entre este momento y el momento de la sentencia, la Corte no estará obligada al acuerdo de la sentencia o a la evaluación y usted no va a tener el derecho de retirar su declaración. Cualquier mala conducta se define como que incluye, sin embargo, esto no se limita a que usted se vaya rápidamente escondidas o que usted no se presente para su sentencia. Violar los términos de las condiciones de usted estar fuera bajo fianza o los términos de cualquier sentencia o cualquier acuerdo de declaración, o de lo contrario, no cumplir con una orden de la Corte pendiente a la sentencia. Si usted no es, I'm sorry, did you go through this? Did you go through I or yes, you did. Si usted no es ciudadano de los Estados Unidos de América, cualquier condena de un delito puede traer como consecuencia su deportación, exclusión de que usted pueda ser admitido en los Estados Unidos de América o negación de su naturalización.
Thank you. Mr. Sanchez, do you have any questions about the rights that I've given to you?
Señor Sánchez, ¿usted tiene alguna pregunta sobre los derechos que yo le he leído a usted?
No.
Okay. So, I'm going to go to number 8. How do you wish to plead to the charge that on or about June 22nd of 2025?
Mire, ahora tengo una pregunta.
Oh, I'm sorry, in the city of Adrian, in the county of Lenawee.
¿Cómo usted quiere? Voy ahora a pasar a la 8. ¿Cómo usted va a desear declararse al cargo de, en fecha 22 de junio del 2025, en la ciudad de Adrian, condado de Lenawee?
That you committed the offense of attempted weapons carrying concealed.
Sí. Usted cometió el delito de haber intentado llevar un arma oculta.
Guilty or not guilty?
¿Culpable o no culpable?
Culpable. Culpable.
I'm sorry, this is the interpreter. I'm going to ask him to repeat because I believe I heard him guilty, but I think he said something else that I didn't hear. ¿Usted puede repetir, señor, despacio, de nuevo?
Culpable.
Guilty.
Okay. Has anyone, I'm moving on to number 9, has anyone made any threats or promises to you to induce you to plead guilty to this charge?
Mire, ¿alguien le ha hecho a usted alguna amenaza o promesa para inducirlo a usted a declararse culpable a este cargo?
No.
No.
We can hear you, but it's harder for her because she's on Zoom.
Sí, y nosotros podemos escucharlo a usted, pero es difícil para ella escucharlo porque ella está por Zoom.
Okay.
So I'm going to number 10. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
Mire, usted entiende que si yo acepto su declaración, usted renuncia o pierde todo reclamo de que su declaración usted la hizo como resultado de promesas o de amenazas que no fueron divulgadas a la corte y que no están en el acta durante su audiencia y que no fue su propia elección a presentar esa declaración.
No.
Do you understand that?
Yeah.
¿Usted entendió eso?
Sí.
Okay. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty?
Sí. El abogado fiscal o el abogado de la defensa están al tanto de alguna promesa o amenaza o inducción, aparte de lo que se le ofreció a él para su declaración, para inducir al acusado a declararse culpable.
Mr. Glazier,
No, other than what we've already placed on the record.
Señor Glacier, no, aparte de lo que ya hicimos constar en el acta.
Mr. Sneed,
No.
Y el señor Sim, no.
Mr. Sanchez, I'm on number 12. Has your attorney promised you any particular sentence or estimated what your sentence will be other than what was placed on the record?
Mire, señor Sánchez, ¿su abogado le prometió a usted alguna sentencia en particular o el estimado de lo que sería su sentencia, aparte de lo que se ha hecho constar en el acta?
Bueno, lo que me dijo fue que 1 año probatoria.
What he told me was that it was going to be a 1-year probation.
Okay. Okay, Mr. Glazier,
Señor Glacier.
Yes,
it's a 1-year delayed probation, so you're, okay. That would be correct, basically, Mr. Sneed, correct?
Sí.
Yeah, or less, you know.
Sí, sería 1 año de probatorio retrasada o menos. ¿Está correcto eso? Así es.
All right, is it your own choice to plead guilty?
¿Es su elección propia declararse culpable?
Sí,
Yes.
So, Mr. Sanchez, on June 22nd of 2025, were you in the city of Adrian in the county of Lenawee?
Mire, señor Sánchez, el 22 de junio del 2025, usted se encontraba en la ciudad de Adrian, condado de Lenawee.
sí,
Yes.
And did you have a 9mm handgun?
¿Usted portaba un arma de mano de 9 milímetros?
sí.
Yes.
And was it in a pocket or was it hidden somewhere?
¿Usted la llevaba en el bolsillo, la llevaba escondida en algún sitio?
No, estaba dentro de un bulto.
No, it was inside a bag.
Okay, and so you couldn't see the gun because it was inside the bag?
Sí, pero no se podía ver el arma porque estaba dentro de un bulto.
Sí,
So it was concealed?
O sea, que estaba oculta.
sí,
Okay, and you don't have a concealed pistol license to carry a concealed weapon?
Usted no tiene ninguna licencia que le permita a usted llevar pistolas o armas escondidas, ¿verdad?
traté de sacarla, pero por mi lenguaje nunca me dieron la oportunidad. Siempre me decían que hasta apuntaba mi nombre, mi número de teléfono, luego te llamaban. Me mantuvieron así tiempo y tiempo y nunca me llamaron.
I tried to, but because of the language, we never, I was never able to get it. They would tell me, write down your name, your number. I did that, but never called me. They never called me back, but I tried.
Okay. All right, Mr. Sneed, are you satisfied?
Sí.
Sí.
¿Estás satisfecho?
All right, has the court, I'm on number 17 now. Has the court complied with the MCR 6.302 B, C, and D?
Sí. ¿Ha la Corte cumplido con MCR 6.30A2 BCD?
Mr. Sneed,
Sí.
Señor, sí.
Mr. Glazier,
yes,
Señor Glacier, sí.
and number 18, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel.
Mire, yo acepto la declaración, la he hecho entendiéndola voluntariamente y con precisión. El acusado tiene conocimiento completo de sus derechos y él tiene también un abogado competente.
This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them.
Esta corte no ha hecho ningún acuerdo con relación a la posibilidad de una declaración o posible sentencia, en este caso, con el fiscal, ni con el abogado de la defensa, ni el acusado, ni nadie más está actuando en el interés de cualquiera de ellos.
Other than the agreement that was placed on the record.
Sí, y ese fue el acuerdo que se hizo constar en el acta.
Ms. Adams, could I get a notice of hearing for sentencing
Señora, ¿me puede dar un aviso de comparecencia?
for January, not for, well, it would be a year, so 11 months.
Sería en un año, 11 meses.
So sometime in October of 26, Ms. Adams.
Entonces, en algún momento en octubre del 2026, señora Adams.
Judge, we could do October 23rd at 8:15.
Sí, pudiera ser
Right.
23 de octubre, 8:15.
Could I get a notice from Mr. Sanchez, please?
Si le puede dar el aviso, la notificación al señor Sánchez, por favor.
Thank you.
Yeah.
All right, I am going to, I'm on number 20 now, so I'm going to refer the matter to the probation department for a pre-sentence investigation.
Mire, yo voy a referir este asunto al Departamento de Probatoria para fines de una investigación previo a la sentencia.
When you leave the courtroom today, I'm going to have you step across the hall to the probation department with your interpreter. He
Mire,
has someone in the courtroom, Ms. Reinhold, too.
mire, cuando yo termine aquí, yo le voy a pedir que usted cruce el pasillo y se dirija al Departamento de Probatoria con el intérprete.
They'll set up a date and time for you to meet with them.
Y ahí le van a dar una fecha y una hora para que usted se reúna con ellos.
There will be a packet you need to fill out information on.
Ahí le van a dar un paquete como de cuestionario que usted va a tener que llenar con su información.
When you meet with the probation department, I'm on number 20. When you meet with the probation department, be truthful about the offense and your background.
Mire, cuando usted se reúna con el Departamento de Probatoria, sea honesto y sincero con la información que usted le va a dar a Probatoria.
I'm going to continue your bond.
Voy a continuar lo de su fianza.
Mr. Sneed, I'm going to stop my share here. Mr. Sneed, you had stated that he could get off probation sooner. So was that if he were able to get his pay off fines and costs and get his CPL? Is that what?
Mire, señor, si usted dijo que quizá él pudiera terminar su probatoria antes, si él paga las multas, costas, y si puede obtener el CPL. And this is interpreted. CPL stands for license for the concealed weapon, right? Si puede obtener también la licencia para llevar una pistola oculta, pudiera también terminar el periodo probatorio antes de tiempo.
Your Honor, there were no conditions. If the defendant wanted to petition early to end probation, the people have no objection.
Mire, no hubo ninguna
Okay.
cuestión. Si el acusado tiene la intención de pedir que le termine su probatoria antes de tiempo, no hay ninguna objeción.
I just want to add there was a mandatory gun forfeiture.
Mire, quiero agregar que parece que una, I'm sorry, this is Deborah, can you repeat that again? There was a,
Mandatory gun forfeiture.
y parece que hubo una falsificación de arma mandatoria. O forfeit is like confiscation, right? Hubo una confiscación de arma mandatoria.
All right. But Mr. Sneed, he will be reporting to Mr. Coast during that period of the delay, correct?
Pero durante ese periodo de retraso, él está reportándose con el señor Coast, ¿correcto? Señor Sneed.
Correct.
Así es, correcto.
So Darren Coast is my pretrial services coordinator.
Mire, Darren Coast es mi coordinador de servicios previo a un juicio.
You will be following his directions for the next 12 months.
Mire, usted va a tener que cumplir, seguir las instrucciones de esa persona en los próximos 12 meses.
Okay,
You will have fines and costs you need to pay off.
Van a haber multas y costas que usted va a tener que pagar.
So I have a few questions for you.
Tengo varias preguntas para usted.
Are you currently employed?
Actualmente, ¿usted trabaja?
no, depende de necesario.
No, I depend on SSI.
All right, so I am going to order that he pay a $30 a month supervision fee.
Mire, yo voy a ordenar que usted pague un cargo de supervisión mensual de $30,
A $250 in court costs,
$50 a costos de la corte,
$68 in state costs,
$68 a costos estatales,
$130 crime victim rights fee,
$130 a cargos a derecho de la víctima del crimen
and $60 DNA fee.
y $60 un cargo por el ADN.
Everything I've ordered is mandatory under the state of Michigan.
Bajo la ley de Michigan, todo lo que yo estoy ordenando es mandatorio, obligatorio.
But I did reduce your court costs by $500.
Pero yo le reduje los costos de la corte, $500 se los reduje.
You can pay this off during the 11 months.
Ese dinero usted lo puede pagar a lo largo de los próximos 11 meses.
Or if you pay it off sooner, you can request to be released from probation.
O si lo paga antes, usted puede solicitar que lo le dejen salir de su probatoria yo antes de tiempo.
Mr. Coast, would you like to meet him in the hallway? He does have an interpreter with him.
I would, Judge.
¿Le
Thank
gustaría reunirse con él en el pasillo, señor Acosta? Porque tiene intérprete. Sí, me gustaría. Gracias.
You get the advice right.
I'll pick it up, yeah.
Okay. All right, my bailiff's gonna have you sign that advice rights. You already did?
Okay, once again,
Mire, mi alguacil le va a pedir a usted que firme la notificación de sus derechos que le dieron.
let me see. That's it.
November 26th of 2025.
Yes.
6 de noviembre del 2025.
Mr. Glazier, anything else?
No, Your Honor.
Glacier. No, su señoría.
I'll fill out the rest of it. You just need to sign it. When you leave here, Mr. Coast will meet with you in the hallway.
Mire, cuando usted salga de aquí, el señor Coast va a reunir con usted en el pasillo.
And then you'll step into the probation department next.
Y después de eso, usted se para ahí por el departamento de probatoria.
If you complete everything, the case will be dismissed. Is that correct, Mr. Sneed?
Mire, y si usted completa todo, lo hace todo, el caso va a ser desechado, desestimado. ¿Es correcto eso, señor Sneed?
No, that was not part of the agreement. It's just a delayed sentence.
No,
Oh,
eso no
it's
fue
just a
parte-
delayed sentence.
solamente fue una sentencia retrasada.
Sorry, I misspoke.
Me equivoqué.
Okay. So go ahead and step in the hallway. I will say that after a period of 5 years, you would be eligible for an expungement. I
Mire,
believe.
párese en el pasillo. Entonces, lo que vamos a decir que después de 5 años, quizás usted sea candidato para que le esponjen su cargo, creo.
And good luck.
Okay,
Buenas
Thank
Thank
you.
you.
Yeah,
Ms. Reinhold, as always, thank you so much.
you're welcome. So I
Have a
think
good day.
I have to go with them, right? Or no? I
No,
think,
they actually, the public defender's office has someone on staff who interprets.
oh, I
They
see.
just can't do in the courtroom, but he'll go with them and help them out there.
Oh, got it. Okay, thank you so much. Have a good day.
All right, thank you.
Welcome. Bye-bye.
Judge, was that no PSI?
Yeah, I sent them over for a PSI. Okay, so, let's see, I got a lot going on here. All right, I have MDOC. Let's see who that is. Hold on one second, everybody.
I believe that's
Yeah.
Mr. Street, Your Honor.
Mr. Street,
Yep.
Steers. Who is it, Miss Underwood?
I believe it's Mr. Street. Kybrian Street.
Yep. Are you Kybron Street?
Yes, ma'am.
Good morning. So let me grab your file and we'll get you taken care of. Okay, this is in the matter of the people of the state of Michigan versus Kybron Street, file number 25-22461FH. I have Rhonda Underwood appearing on behalf of Mr. Street, and I have Isaac Sneed appearing on behalf of the people. So, Miss Underwood, this is date and time set for arraignment in this matter. Do you waive the reading of the felony information?
Your Honor, we would waive the reading of the felony information, acknowledge its receipt and the receipt of the witness list and request for discovery. We would ask the court to enter a not guilty plea on Mr. Street's behalf and set this matter for a pretrial in the coming weeks, Your Honor.
All right, my next available is January 14 at 8:30 in the morning, January 14 at 8:30 in the morning. Because it's arraignment, we will do the notice of hearing and I will enter a plea of not guilty on behalf of Mr. Street. So Mr. Street, we will see you back here on January 14 at 8:30 in the morning, okay?
Okay, will that be on Zoom or in
It'll
person?
be on Zoom. Yes, sir.
Okay,
Where are you currently at?
Saginaw Regional Facility.
Okay, yep, it'll be Zoom. Thank you, sir. Ms. Senkowitz, this could be hours before I get to the pickup, just an FYI, okay?
That's okay. I'm good with that. Thank you, Your Honor.
All right, I'm gonna will you turn off your video though? So I usually only have the video for the attorneys that are talking to me. That's how the prosecutor does it. And I don't get all distracted. All right, Mr. Street, I'm gonna send you on your way, okay?
Have a good day. Thanks, good.
Have a good day. It's okay. Let's see, gentlemen in the front row, do you have a court case today?
Yes, ma'am.
What's your name? Say it again. Iadali? Okay, you're Mr. Malero's client. Is anybody, young man in the back? How about the people in the middle? Do you have a case
I have a
today?
9:30, Your Honor.
Okay,
Got Thompson.
yep, okay. All right, it'll be a while. I'm sorry, there'll be some delays. Okay, so. I think. Hi, this is Judge Anslow. Oh, I called booking. I meant to call transport, didn't I? I thought,
Okay.
okay, bye.
Bye.
You're welcome.
Hi, this is Judge Anslow. How are you?
Not too bad, ma'am. How are you?
I am good. So I'm ready for Israel Vila,
Okay,
Todd Bowie,
okay,
Robert Allen,
okay.
and Craig Rosenkrantz.
All right,
We did have a waiver on Latasha Flores, so we won't need her today.
okay.
All right, thank you.
You're welcome. Bye-bye.
Bye. All right, I have Sky Shun Tyndall, Miss Underwood.
Thank you.
No. All right, Mr. Tyndall, good morning. So this is in the matter of the people of the state of Michigan versus Sky Shun Tyndall. We have file number 20-20027FH, 22-20717FC. I have Rhonda Underwood appearing on behalf of Mr. Tyndall. This is the date and time scheduled for a probation violation. Miss Underwood, how would you like to proceed today?
Your Honor, can I have a breakout with Mr. Tyndall? Or perhaps I should have a breakout with Ms. Holly first. If I
There's a
could do
bench
that.
warrant out for him. Your Honor signed a bench warrant.
All right, so it looks like there is a request and warrant for probation violation dated November 4. On September 16 of 25, he was instructed to report on October 7 and on October 28, or a bench warrant would be issued, and he has neither reported or called the agent since then, and he's failed to pay court order costs and restitution totaling $1,188. He currently owes $838. That is the technical probation violation. And then he has a non-technical probation violation, which alleges that on, well, that's the same, I think the same one, May 9 of 25, he was pulled over for driving on a suspended license, pled guilty to allowing an unlicensed driver to drive on May 20 of 25 and sentenced to pay fines and ordered for review on July 22nd of 25. And he failed to show, and there's a current warrant pending in district court. So that warrant's still pending, Miss Holly?
I'm looking right now. I assume it is. I will look right now, though.
Can I just say one thing, please?
Nope. I don't want you to say anything yet, Mr. Tyndall.
Yes, ma'am.
Because you know, anything you say can or will be used against you. I need that little button for NCI, you know? Huh? No, that little button for, was it criminal, what's that show?
Yeah, I know.
For some reason, I'm having trouble getting on the court computer. I don't know if your staff can get on there. Oh,
I
wait,
still
here it
have it.
comes. Here
I
it
still
is.
have it.
Okay.
Oh, hold on, Mr. Tyndall, hold on. So, Miss Underwood, why don't I have Miss Adams email you a copy of the request and warrant for probation violation? And then maybe put you in a breakout room with Mr. Tyndall?
Thank you, Your Honor.
All right.
Yep.
Miss
I see it's
Adams?
still active.
Okay. All right, so, all right. So Miss Adams will come get that file and email, or she'll email it to you somehow. And I'm gonna open up a breakout room, and then I'm gonna take care of Mr. Noe's file.
I would like a brief bench trauma. I can't even get that one started.
Okay. All right, who's the prosecutor?
Oh, I don't, it's a sentencing, so I think we just need Sarah. I mean, a prosecutor.
So Miss Teskey is not here today?
I don't have any prosecutor's file.
All right, so Mr. Tyndall and Miss Underwood, join that breakout room. All right, Miss Teskey, I'm gonna step in the hallway with Mr. Noe and I'll call you, okay? I don't think she's gonna answer. Good morning. How are you, Ben?
How are you?
Fine, thank you. How are you?
Checking on you. Okay. Furniture. Great, absolutely. All right, cool.
Morning, Mr. Murphy.
Please rise for personnel session.
Right.
I can sit, right?
If you want to. We usually
Come on,
stand up here.
Come on, stand, maybe.
But I know you're getting older, and if you need to sit, that's fine.
Only 40, give me a break.
Okay, so this is in the matter of the people of the state of Michigan versus Cody Joseph Lowe. Mr. Noe had requested a bench conference. I did take an opportunity. We called Ms. Teskey back and we had a conversation with Ms. Teskey. Mr. Noe, you received the probation violation recommendation report.
I certainly did.
All right, and you've had time to review that with Mr. Lowe.
This morning we had a few minutes, yes.
All right, so Mr. Lowe, you've had an opportunity to read and review the recommendation.
Yes, Your Honor.
Okay, and you've had ample time to talk to your attorney?
Yes, Your Honor.
Okay. Are you satisfied with Mr. Noe and the advice that he's given you?
Yes, Your Honor.
Mr. Noe, do you wish to explain or challenge the accuracy or relevancy of any information in the probation violation report?
No, you're just a brief statement for myself and my client before sentencing.
All right, so, is there anything you'd like to say on behalf of Mr. Lowe?
Thank you, Judge. Thank you. There is some things I want to say on behalf of Mr. Lowe. Hopefully I'll be as quick as possible, Judge, but there's quite a few things I want to say. Judge, I want to bring up first off and foremost that we're acknowledging the seriousness of Mr. Lowe's third violation. He knows he's been given chances, probation, drug court, treatment. And as he stands here today, he owns the failures that he's had with those things. But the question before the court, I think it's important to note, because I think the Department of Corrections is recommending the prison sentence, is what that consequence should be. There absolutely should be. I won't argue with that. The question is whether that consequence would be proportional and what consequence actually promotes rehabilitation instead of setting my client back months, if not longer, in his rehabilitation process. Judge, we are asking for a 1-year sentence. I know the court is not inclined to grant that, but we are asking the court for leniency. We are asking the court that fits the violation, fits the guidelines, and ultimately fits the reality of Mr. Lowe's situation. First off and foremost, I want to bring to the court's attention that all these violations are technical, not new crimes. These are new crimes my client had been convicted of. Ultimately, I think that I'd be having a much different tune this morning. There's been no assault. There's been no threats, there's been no weapons, no violence, no criminal behavior other than, unfortunately, my client's battle that he's had with addiction. I think that you could draw a line here between a criminal reoffense and a relapse-based non-compliance, which I think we have here. And an appropriate response here is a structured local sanction that's not a multi-year Department of Corrections sentence. My client's already served a meaningful amount of time. He's been in jail since October 1st. October 1st, and he has been obviously went through a time as the jail indicated sort of detox, but my client was on methadone, so it's off that, so that's what he had to detox off of. He's had long sustained periods of sobriety and stability. He's receiving his prescribed medications, a blood pressure medication. He ultimately has been truthful and cooperative from these violations. Jail is working. My client is making meaningful change. Department of Corrections is not needed in this matter. Obviously, for the assault file, the guideline minimum is 0 to 17. 1-year jail sentence would fit squarely within that. For the drug file, that is ultimately a 29 to 57 month calculation. Obviously, I was not his attorney at the time those were calculated. But the conduct underlying the violation here does not justify some sort of prison term. These are relapses. These are substance use violations. Judge, if the court really wants to consider, one of the things the court has to consider here is obviously punishment, which we're certainly acknowledging, but ultimately one of the goals here is rehabilitation. My client has a fiance, he has stable housing, he has a legitimate business, he owns and operates, his family supports him. A years-long prison term is going to destroy that employment. It's going to sever his support network and eliminate his recovery momentum. While a jail term would not do all those things. The court's goal with Mr. Lowe, to its credit, to its great credit, has always been rehabilitation of Mr. Lowe. The court has worked for a significant amount of time, Mr. Lowe, longer than I have, in fact. The court gave him a downward departure before the court because he could change. And frankly, that opportunity, you'll rightly say, he has taken that seriously until he had a relapse. Jail has been obviously a wake-up call for him. He went through a very rough time, especially when he was first incarcerated. Again, he's not asking for probation right now. He's not asking for just time served. That would be, I know that's wildly unrealistic. I know it's not possible. I know it's not what the court's looking at. But ultimately, he is asking for a meaningful sanction. Judge, looking at a jail term or a significantly shortened with the Department of Corrections term does fulfill all the goals of this court. He'll have a punishment. He's spent in jail since for almost 2 months on this incident violation. He has no deterrence. He has no desire ever to go back. Again, I know the court didn't talk to him. I did, and I can tell you right now, especially when he first went in regarding coming off that methadone, it was rough. It was really, really, really bad. I spoke to the jail sergeants. It was bad. It was really bad. I spoke to him on the Zoom. It was bad. Obviously, jail has forced the clarity that my client needs in sobriety. And in terms of ensuring public safety, there's been on these violations, no new assaultive crime, no new crimes he's been convicted of, none of that. So, Judge, for all these reasons, we are asking the court to impose a county jail sentence. Credit, I did calculate the credit for my client. Department of Corrections, obviously.
Yeah, I'm on Zoom.
Mr. Sneed, go ahead and mute yourself, please. Thank you.
The Department of Corrections did calculate that credit. That's correct. My client does concur with that. Judge, this is a serious sentence, but it needs to be a fair sentence. And a sentence that gives Mr. Lowe accountability while preserving the possibility of a long-term rehabilitation, which I think, again, if my client had committed some sort of violent offense or something like that, again, I'd be seeing wildly different too. That's not the case here. So I think the Department of Corrections, I think the recommendation, while they are recommending their guidelines, I don't think is appropriate given that these are obviously technical violations, and that ultimately, I think that my client again would benefit from that, from the sentence I recommended, and ultimately I think that my client does want to say some things. I think he wants to take some. I know usually I tell my clients I don't want them to say anything for obvious reasons, but in this I think my client does want to. I think my client wants to come forward and take some responsibility and tell the court his own words. So if you can get that opportunity this morning.
Mr. Lowe, is there anything you want to say on your own behalf before the court passes sentence?
Yes, Your Honor. First, I want to take accountability. So I shouldn't have not reported to Sarah. Definitely shouldn't have crossed state lines. And I definitely shouldn't have used, obviously. That's one of my biggest mistakes, which sent me on a huge spiral. When Sarah called me and gave me the courtesy call she gave me that a warrant was coming out, it was just all downhill from there immediately afterwards. Though I started that by crossing state lines, I do take full accountability for that. I do want to thank you for giving me drug court. I appreciate that because it gave me like just huge growth in my life while I was on drug court. I wish that when I went to rehab, I would have had more time there because I was only there for 11 days before they completed me. So I feel like if I had more time, I maybe would have done better.
Mr. Sneed, you're standing.
Yes, Judge. Not many cases do we have the probation department request a prosecutor at a sentencing. This is an exception here. Ms. Teskey reached out, is requesting the people to appear, requesting the court to adopt a recommendation by the probation department. And if the court would like to hear from Ms. Teskey, I think she's prepared to state the reasons why.
Ms. Teskey, is there now, Ms. Teskey, I call you only as you were one of the team leaders in the probation department for the recovery court program, which Mr. Lowe was in. So of course, is there anything you wish to add to your recommendation?
No, Your Honor. I rest on the comments I made in the bench conference.
Now, you did attach to your pre-sentence report the photographs from the victim in the assault case. Is that correct?
That is correct.
All right.
I don't have those.
We're going to hand that down to you. I don't know if that was just part of the file and she attached it.
I don't know why I would not be provided that.
Well, it was part of the original PSI, so it's attached to the original
reference.
PSI that's always put in my file. Mr. C. Yeah. Oh, Mr. C would like to see them as well.
I wasn't to the bench conference.
I have a chance to review that. It's the first time I've had a chance to review that or know that was part of the sentencing, so I can respond to that briefly.
Well, that was part of the PSI. I just wanted you to know
Certainly.
that they were here.
Certainly.
Okay.
And I've had a chance to review those, and ultimately, I understand those are severe, and I understand just seeing this first time, obviously that's severe. But that being said, that was taken into consideration at the initial sentencing. I don't know if the court's inclined to use that as a reason or enhancement.
No.
Okay.
I'm just letting you know they were there.
And that's fine. I just wanted to clarify that hopefully that was used in the initial sentence. Again, that we were just on these violations, not on new conduct or something like that. I certainly get that. Matter of fact, I think those help my client because that show, yes, He certainly did looks like very horrendous thing. He ultimately took responsibility for it. That's not what we're here for today.
Okay. All right, so when we were initially here for sentencing way back on March 1 of 2024, the initial recommendation from the probation department on file number 21-20527FH was for an MDO sentence of 1 year to 1 year, 11 months to 10 years. And that would be for the assault with intent to commit great bodily harm. And then on 23-21347FC, the recommendation at that time was for a sentence of 29 months to 20 years with the Michigan Department of Corrections. You have excellent counsel representing you today. Mr. Noy was very eloquent today. You as well, Mr. Singh. But Mr. Noy was very prepared and very eloquent and did talk about the advancements you've made, but also understanding that there have been some concerns. So the initial sentence is now the same recommendation as for today. At the initial sentence, there was downward departure as part of a plea offer that was made. You served 1 year in jail. We did release you to boot camp. You successfully completed boot camp. Then you were ordered to enter and complete the drug court program and placed on probation for a period of 3 years. We're here today because while you did successfully complete the boot camp program, and by all appearances, you were doing really well in the recovery court program, but you really weren't. You were abusing, you were hiding, you were forging documents for treatment classes, and you left the state. And you initially lied about what happened when you left the state. So it's almost been like you're taking advantage of the recovery court, you're getting what you need from it, but you were living this double life the whole time. Your support system is there now and will always be there. You are loved by your family, by your fiance. You work really hard. You have the ability to be successful, which is why you got the deal you got, right? And, you know, we all like you. We've all enjoyed working with you, but, you know, at the same time, I feel like to some extent you were playing a game with us. Like you thought you were smarter than us. And here's the deal. Everybody gets caught. You always get caught, whether you're my kid, Mr. Seed's kid, Mr. Noe's kids. They're not old enough to cause trouble yet, but they will. And then even you, and you know, and you have your dad to look to because you saw what he went through and what it took for him to get where he is today, right? And you got to fix that because at some point you're going to be a dad too, right? Mr. Glazier, could you mute your device, please?
Sorry about that.
Okay. You know, so the victim at the initial sentencing, I believe, wanted I think he wanted more of a sentence than plea agreement that was worked out. So I can't downward depart again, but I will take into account what you have done. I wish I could send you to boot camp. I wish there were other options left, but you've burned through them. So it's a sentence of the court that on file number 21-20527FH, has he paid his fines and costs off, Ms. Teskey, on all these files?
No, Your Honor, he owes significant restitution on that assault case.
Yeah, I know. Okay.
My client has paid some fines and costs.
Yeah, he's paid. He's been paying this recovery court.
This has to answer the question. I wanted to question.
All right. So on file number 21-20527FH. Let me get to the right. 20527FH. Sentence of the court, you'll serve 17 months to 120 months with credit for 178 days. On file number 23-21347FH, that's one where your guidelines, there was a downward departure. It's a sentence of the court that you will serve 23 to 240 months with the Michigan Department of Corrections, and will give you credit for 178 days. I'm giving you some credit for the work that you've done, but Mr. Lowe, there are services available through MDOC. I'm gonna order that he enter, any programming that would be appropriate for him. Mr. Lowe, your family and your support system will be here when you get out. Your work will be here when you get out. You've done it before. You look worse than I've ever seen you. You have circles under your eyes and you look sick just sick about all of this. And I don't blame you. But I want good things for you, but my hands are kind of tied in this situation because of the guidelines. And so I want you to succeed and I want you to get out and I want you to do better. No more of this. Don't be 55 like your dad when you finally get it. Okay? I don't know how old your dad is. So if he's mad, I've said he's older than he is. I apologize. So my bailiff's going to hand down to your notice of right to appellate review. There's one for each file. I want you to initial and date your each copy on the top. The other 2 copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Anything else, Mr. Sneed?
No, thank you.
Ms. Teskey?
I'm good, Your Honor.
All right, thank you.
Thank you.
Hold on, Ms. Underwood. Good luck, Mr. Lowe. Thank you, Mr. Noe. Record to reflect the receipt back signed copy of notice of right to appellate review. So, Ms. Underwood, we are back with Mr. Tyndall. Have you had an opportunity to speak with Mr. Tyndall?
I have, Your Honor. Excuse me.
How would you like to proceed?
I would ask the court to enter a not guilty plea on Mr. Tyndall's behalf. Your Honor, I've talked to Mr. Tyndall. Mr. Tyndall has been working very hard to get the money together to come in. It's my belief, or it's Mr. Tyndall's representation, Your Honor, that by the 2nd, he will turn himself in with all the money to pay everything off. And so I would ask for a not guilty plea, and perhaps we could set another date.
So I will enter a not guilty plea. Mr. Tyndall, you show up for court every time. Wounded, healthy, whatever. You always show up for me. You guys show up for Miss Holly.
No, yes, ma'am. Yes, ma'am. I know. It's
Okay.
just, I just don't want to be locked up without no money. Yes, and I got 4 kids. I'm so sorry. And I take responsibility for everything I've done.
Okay, hold on. So you got that bench warrant in district court. There is nothing I can do about that bench warrant in district
Yes, ma'am.
court.
Yes, ma'am.
All right, so, Ms. Underwood, the warrants stay in place. He needs to turn himself in.
I will. I promise I will.
All right, so on our plea of not guilty, I'll set another pretrial for December 17 at 8:15 or 8:30 in the morning. So Mr. Tyndall, December 17 at 8:30 in the morning. And I want Miss Holly to tell me that you turned yourself in, okay?
Yes, ma'am.
All right,
So,
thank you.
so our bench warrant still stands?
Yeah.
Yep,
Okay, thank you.
thank you.
Thank you.
Thank you. Mr. Monterez, where's he at? I thought I had him. Usually when I have all the attorneys, it goes fast, but not today. All right, Mr. Monterez, you represent Mr. Shelton. Stephen Shelton, can you unmute your device and start your video? And Nicholas Monterez, could you as well? Thank you. Mr. Shelton. Stephen Shelton. All right, he's not answering yet, Mr. Monterez, so give us just a minute.
No problem, Your Honor. I'll send him a text message.
Okay. Robert Allen, Matt Murphy.
Morning, Your
All
Honor.
right, in the matter of the people of the state of Michigan versus Robert D. Allen, we have two files, 25-22467FH, 25-22468FH. I have Matthew Murphy appearing on behalf of Mr. Allen, and Mr. Allen is appearing from the jail. I have Isaac Sneed appearing, Alexander Bayanetto appearing on behalf of the people. And this is the date and time set for arraignment on file number, why do I have two files? I got file number 25-22468 is set for arraignment today. 6-7 is, oh, wait, I gotta look at, oh, they both are. All right, hold on, let me look at Judge Olsaver's docket, because I believe this is, huh? And one's mine?
Hi.
Okay,
This is
so
Rhonda
I don't know
Underwood,
why, but I have
and
one
I
and
have
Judge
Gracie,
Olsaver.
my
Brenda, somebody's talking.
Judge, they're both yours, or both Olsaver, I'm sorry.
Okay.
Oh, okay. So they are both Olsaver's files and 25. All right. So they're both set for arraignment today. I'm sorry. So, Mr. Murphy, do you waive the reading of the felony information?
Yes, Your Honor. There was confusion. I had both Your Honor and Judge Olsaver down on the files. But yes, Your Honor, we received the information witness list and discovery demand by the prosecution in this matter. Would ask for a continuation of a not guilty plea at this time, setting up a pretrial. And if I could just have a breakout with Mr. Allen, I could speak with him briefly and then I could move along.
So I will enter a plea of not guilty on behalf of Mr. Allen on both of these files. And a date will be set by Judge Olsaver's staff unless Ms. Adams, do we have a date?
Judge, I believe she sent dates with his docket.
All right, so you will get a notice of that. Mr. Allen, I am going to put you in a breakout room with Mr. Murphy. Fine, Matthew Murphy. Mr. Allen, I think you're in jail Zoom 4, correct? 1. 6? 6. Okay. 6. All right. What?
Those dates should be with his docket.
Okay. All right. So, let's see. So, Mr. Stephen Shelton. I don't have him. Oh, he logged in again. All right. He must have froze.
Yes, Your Honor. He got back to me. He said that there he is.
Yeah. There he is. Okay, this is in the matter of the people of the state of Michigan versus Stephen Anthony Shelton, file number 25-22366FH. I have attorney Nicholas Monterez appearing on behalf of Mr. Shelton and Dave McCready appearing on behalf of the people. This is the date and time. This is set for pretrial. Let me find Mr. Shelton. Where is he? There it is. So Mr. Monterez, we didn't get a stipend order to adjourn to today. So we're going to need, a stipend order adjourning from October 22nd to today.
No problem, Your Honor. I'd ask my staff to mail it out, but I'll check with them and I'll make sure to get a new one out if you don't have it.
All right. And Mr. McCready, I'm assuming he can sign your name with permission.
That's fine.
All right. So this is date and time set for pretrial. So Mr. Monterez, how would you like to proceed?
Your Honor, I've been in communication with Mr. McCready. We actually exchanged some messages just before we called this case. We're waiting on some testing results from the Michigan State Police Lab. Got an update from Mr. McCready that they received the report today. I think we're both looking for a brief adjournment to discuss the results of that testing and hopefully come to a resolution.
So my next available day is January 14 at 8:30 in the morning. And Mr. Monterez, so I'll need the stip in order from October to today, and then one from today to January 14 at 8:30 in the morning. And Mr. McCready, can you sign your name with permission?
Again, that's fine.
Okay. All right, so Mr. Shelton, we will see you back on January 14 at 8:30 in the morning, all right?
Okay, thank you.
All right, thank you.
Thanks, John.
Let's continue. Okay, so. Mr. Dagger Margosian. Mr. Rakowiak.
Judge, he is on.
Yes, ma'am.
Oh, there he is.
No. Will you pronounce your last name for me?
Rahovi.
Rahoviak? Okay, you're kind of breaking up, but okay. So, and this is, it's okay. File number 25-22431FH. I have a prosecutor. Do I have a prosecutor on this one? I have Isaac Sneed appearing on behalf of the people, and Michael Dagger Margosian appearing on behalf of Mr. Rahoviak. This is date and time set for a first pretrial in this matter. Mr. Dagger Margosian, how would you like to proceed?
Your Honor, good morning. Mr. Rahowiak is doing the Economic Crimes Unit program. He has been making payments. But there is more of the balance that he needs to pay. I would just be asking for an adjournment today.
All right. And how far out?
Maybe 45 days.
About January 21.
Yeah, that's great.
And that'll be at 8:30 in the morning. So Mr. Rahoviak, we'll see you back January 21 at 8:30 in the morning. And Mr. Dagger Margosian, can you do the step in order to adjourn?
Yes, Your Honor.
All right, Mr. Rahoviak, keep making payments. Thank you. Bonds continued.
All right.
Thank you.
Thank you.
Nathan Steers, want to come on up? So this is in the matter of the people of the state of Michigan versus Nathan Dwayne Steers, file number 25-22429FH. I have Michael Dagger or Isaac Sneed appearing on behalf of the people, and Michael Dagger Margosian appearing on behalf of Mr. Steers. Mr. Steers is present in person. Mr. Dagger Margosian, how would you like to proceed today?
Your Honor, I was unable to talk with Mr. Steers before today. Could he do a breakout room, please, in the hallway?
Okay. So do you know how to use Zoom?
Kind of, yeah.
Okay, so you're gonna go out in the hallway. You're gonna take a left. I'm gonna follow my bailiff.
Thank you, Your Honor.
Yeah. I made him rescue a bat from the courtroom the other day, and now he does IT for me as well, so. Mr. Rosencrantz, can you hear me?
Yes, ma'am.
All right, Mr. Mr. Glazier, are you with us?
Yes, I am.
Hold on 1 second. Let me open up a breakout room. I'm gonna close the breakout room and open a breakout room. So hold on.
Solid direction.
All All right, so I'm gonna send a request to the hallway Zoom, Mr. Steers, for you to start your video. And then I am going to put you in a breakout room with Mr. Dagger Margosian. Go ahead and join that, and Mr. Steers, when you're done, leave it running and just come in the courtroom, all right? Just leave it on and don't worry about it, come in the courtroom.
Okay.
All right, so this is in the matter of the people of the state of Michigan versus Craig Barrett Rosencrans, file numbers 25-22459FH, 25-22460FH. I have John Glazier appearing on behalf of Mr. Rosencrans, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for arraignment. Mr. Glazier, how do you waive the reading of the felony information?
Yes, I do, Your Honor.
And how would you like to proceed?
Your Honor, I have two files for Mr. Rosencrans. Do you have two as well?
Yep, I called both of them. I thought, I'm sorry, 25-22459 and 25-22460.
Yeah, Your Honor, we would waive the reading of the information and enter a plea not guilty, ask the matter to be set for pretrial. Is Mr. Rosencrans on Zoom right now?
Yep, he's right there in jail Zoom wearing oranges.
Okay, could I speak?
Mr. Rosencrans, wave.
I need to
There he
speak with
is.
Mr. Rosencrans. I was under the belief he was in a program, so if I could speak with him.
So, Mr. Glazier, just to give you an update, Darren Coast went to the jail to do a pretrial assessment, but there is an active hold from Washtenaw County on Mr. Rosencrans, and they do intend to pick him up. He has a theft charge pending in that county. So I will open up a breakout room for you and Mr. Rosencrans. Let me find his jail Zoom. I think you might be in a Polycom room, Mr. Rosencrans, so you'll go automatically. So I'm gonna try this. All right, yeah, click on join. Yep, he did. All right, there you go, Mr. Glazier. All right. Somebody sent me a message on Bowie. Who's handling Bowie today? Sam? Yes. Mr. Malaro?
That would be me, Your Honor. I'm handling Mr. Bowie.
All right, yeah, Diane's not gonna be here. He sent me a chat. All right, so Mr. Bowie, let me grab your file. This is in the matter of the people of the state of Michigan versus Todd Jerome Bowie, file number 25-22401FH. I have Salvatore Malaro appearing today on behalf of Mr. Bowie for Diane Malaterno. And I have Alexander Bayonetto appearing on behalf of the people. Thank you for the chat, Mr. Malaro. So I knew that. All right. So Mr. Malaro, how do you wish to proceed on the pretrial today?
Your Honor, I have a message from Ms. Moliterno that Mr. Bayonetto had changed the plea offer a little bit. And so I'd ask to adjourn this for Ms. Moliterno to discuss that with Mr. Bowie.
All right, so I will set this over to December 17 at 8:30 in the morning for another pretrial. And Mr. Malaro, you'll have Ms. Moliterno do the stip in order to adjourn. Mr. Bayonetto, can you sign your name with permission?
Yes, Your Honor.
Mr. Bayonetto, what is the current plea offer?
Your Honor, it is as charged, no subs, no further upfront jail.
At sentencing or at the time of the plea?
At the time of sentencing, Your Honor.
All right, I've written that down. So, Mr. Bowie, we'll see you back on that day. All right, Mr. Bowie?
All right.
All right, thank you.
Thank you, Judge.
All right, thank you. Okay. got Mr. Rosencrantz back. So, Mr. So, Mr. Glazier, how do you wish to proceed today on behalf of Mr. Rosencrantz?
Your Honor, Mr. Rosencrantz was screened for drug court, but I don't know whether he was admitted into that or not.
My understanding is he is eligible.
Okay. I want to try to take care of this then as quick as I can. If I could adjourn it just 1 week, what I want to do is enter a plea here. And then try to get him in because he was in a program and he
So,
left.
Mr. Glazier, we can't take him into the program till he takes care of Washtenaw County.
I
So
understand.
he's eligible, but he has to deal with Washtenaw before he can start it.
Washtenaw County is just a misdemeanor charge, is what he tells me. So
Okay, good.
So once he takes a plea here, if he can be released there, then we'll take care of it. We just want to get him back into a program. He left Dawn Farms to come here and take care of this matter. And I sent a letter over from Dawn Farms therapist.
So I'm gonna set this over to December. I'm gonna enter a plea of not guilty on behalf of Mr. Rosencrantz. And then I'll set this for a pre-trial on December 17.
Is there any days at all or earlier than that, Your Honor?
I mean, if you decide, no, you guys, everything keeps getting adjourned, so my dates are all full. Mr. Glazier, in the event you work out a plea agreement, I will take him anytime available. It doesn't have to be just on a Wednesday, but I'm gonna set it for a pre-trial on December 17th. If he takes care of everything, you probably can Zoom to Washtenaw County. I think they're really reasonable about that. You can bring them in sooner, but I'll set it for December 17th. So, Mr. Rosencrantz, obviously, I'm sad that you're back here again, but I'm glad that you're willing to explore recovery court again, because, you know, we do want that for you. So we will see you back sooner probably, but if not, December 17th at 8:30 in the morning. And hopefully, Mr. Glazier, you can reach out to Washtenaw and see if they'll Zoom him in on that misdemeanor or something, all right?
That's fine, Your Honor.
All right, so we'll do the notice of hearing because it was an arraignment. Thank you, Mr. Rosencrantz.
Ma'am,
Yes, sir.
can I break out with Mr. Glazier again?
Mr. Glazier, can you join the, are you available for the breakout room?
Yes, Your Honor.
All right, so hold on a second. Got to close the rooms first. Hold on. So I'm going to open the breakout room again. All right, so Mr. Steers, come back up. So we are back on the record in the matter of the people of the state of Michigan versus Nathan Steers. Mr. Dagger Margosian, how would you like to proceed with Mr. Steers?
Your Honor, I now have good contact information for Mr. Steers, and I asked him to set up an appointment with me to go over the discovery at my office. Due to that, and I think this is probably the first or second circuit court pretrial, I would just ask for an adjournment, please.
Ms. Adams, could I get a notice of hearing for January 21 at 8:30 in the morning?
Yes, and who is this judge? I'm sorry.
Nathan Steers, file number 25-22429. So Mr. Dagger Margosian will do the notice because he's here and I want to give him that in person, okay? So just have a seat right behind you on that bench behind you and we'll get you a notice of hearing, all right?
Thank you.
So, is that all I have with you, Michael? Dagger Margosian?
Yes, Your Honor.
Underwear, why are you still here? Did I take care of all yours?
I have, I believe, a pickup.
Okay, I'm not there yet. I'm sorry, Miss Underwood. All right, Mr. Murphy, James Hall.
He should be zooming in. Let's see.
I got him. And then I have Mr. Vila. All right, do you need, are you taking a plea on Mr. Hall today?
No, Your Honor, we're gonna ask to adjourn for one more free
So
trial.
this is in the matter of the people of the state of Michigan versus James Albert Hall, file number 25-22427FH, 25-22428FH. I have Matt Murphy appearing on behalf of Mr. Hall, and I have Alexander Bayanetto appearing on behalf of the people. And this is your case, Mr. Bayanetto, correct?
It is, Your Honor, yes.
All right, and so, Mr. Murphy, how far out are you asking for an adjournment?
Whatever fits the court schedule best. Mr. Hall is in Bear River treatment right now. He's gonna go to transitional housing, I believe, on December 8th. So I just wanted to make sure that he was doing well, and then readdress the people's offer, and speak to my client further about that. So again, whatever fits the court schedule best. I understand that you have a lot of things coming up.
Okay, Mr. Coast, are you in your office? All right, so I have a note from Mr. Coast saying that Mr. Hall had a scram unit on until he got into Bear River Treatment Facility. As of November 13, he was still in the treatment facility without an update. Are you still there, Mr. Hall?
I am here. Yes, ma'am.
Excellent. Understand, Mr. Hall, when you get released, you need to be back on a scram unit or a remote breath machine. So when you get released from there, you got Mr. Coast's phone number, right?
I do. I'm headed to another treatment facility, and that is a 1-year program.
Where's that at?
That is in Battle Creek. It's called The Haven. I leave
Even
on
the Haven?
The Haven. I leave on December 8th for The Haven.
Wait a second. Is it Haven, the Haven?
I think so. I think that's how you.
And it's in Battle Creek.
Correct.
All right. You will need to sign a release so that Mr. Coast can get information to verify.
Okay, I thought I've done that already.
We did that where
but
you
not
are.
for the second facility that you're going to. So if you do go there, make sure you sign a release so I could talk to them.
Okay. I don't know how to do that.
You tell them I need my pretrial services guy to be able to contact you, and you give him his name. You just need to tell him you can release my information to Darren Coast.
Okay.
Okay.
All right, I will do that.
Excellent. So I'm gonna set this for pretrial, unless Mr. Bayanetto objects.
No, Your Honor.
February 11.
Yes, Your Honor.
Mr. Bayanetto, do you object?
No, Your Honor.
All right, so I'll set a pretrial for February 11 at 8:30 in the morning. Mr. Hall, write that down, February 11 at 8:30 in the morning, because I don't know if your notice will catch up to you. You stay in contact with Mr. Murphy and Mr. Coast, keep everybody updated. And then if you are removed from a program or anything else, you need to report to Mr. Coast right away. You got it?
Okay, so I'm letting you know right now that that's where I'm going, and I'll
Yes, sir.
a release of information.
Your Honor, do you
Okay.
want my
Thank you.
office to prepare a stipulation order for those dates, time, February 11th?
Yes, of course. And Mr. Bayanetto, can you sign your name with permission?
He can, Your Honor. Thank you.
All right. Thank you, Mr. Hall. Good luck.
Thank you.
Thank you, Mr. Hall. I'll be in touch with you, okay?
I appreciate it.
Thank you.
Have a great Thanksgiving, you guys.
You too. Thank you.
All right,
Good
thank
luck.
you. Thank you, dear.
Mr. Iagulli, you want to come on up? You can sit because you're in
Am I done?
crutches, so I don't want.
Am I done? Can I sign out?
Yep, you're all set, Mr. Hall. Thank you.
Thank you.
So Mr. Iagully, we're gonna have you sit at that table and my bailiff will move the microphone up for you. Mr. Malaro, you have Mr. Iagully. All right, this is in the matter of the people of the state of Michigan versus Angelo Craig Iagully. I pronounced that right? Okay, gotta speak real loud for me, okay? All right, and it's file number 25-22412FH. I have Salvatore Malaro appearing on behalf of Mr. Iagully, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial conference. Mr. Malaro, how would you like to proceed?
Your Honor, I asked to adjourn this matter one additional time. Mr. Iagully's been pretty good staying in contact with me, but due to his recent calamity, we've had a little difficulty of him getting into my office so we can discuss the matter in more detail. That's the basis for my request.
All right, this is only the first well, no, this might be more than the first, but it might be the first pretrial. I think it is the first pretrial, second pretrial. Right. Plea offer is plea discharge to an aggravated assault misdemeanor. The felony would be dismissed on count 1. And then there's a district court file number 25-1416 SD that he would have to plead to, and everything else would be dismissed. Is that still the plea offer, Mr. Sneed?
Yes.
Okay. So I'm going to adjourn this to February 4 at 8:30 in the morning. And Ms. Adams, could I get a notice of hearing from Mr. Iagully for February 4 at 8:30 in the morning? Hopefully you're healed by then. We'll do the notice, Mr. Malaro.
Thank you, Judge.
Great, so you just stay right there. You're good. We'll get you a notice of hearing and then you are free to go. All right? So don't get in any trouble. Okay. All right. I've got Cade Packard.
I got a question. Can I go talk to my lawyer while I'm here?
Mr. Malaro, can he come over to your office, Mr. Iagully?
Yeah, absolutely.
Yeah, okay. Wait for your notice and then you can limp over there. All right. So I have Mr. Packard. So this is in the matter of the people of the state of Michigan versus Cade Robert Packard. File number 25-22394FH. I have Salvatore Malaro appearing on behalf of Mr. Packard. I have Isaac Sneed appearing on behalf of people. So I have a letter dated November 25 of 2025. It states, Mr. Coe states that Mr. Packard has done an awful job with his testing. He missed his November 17 drug testing after testing positive for cocaine 2 times. His November 21 and November 24 tests were both positive for THC and alcohol. He claims he applied for a medical marijuana card, but is yet to provide me with verification. He's facing meth charges and actively using cocaine, THC, and alcohol. It is apparent he is an alcohol. Their recommendation is to lodge him pending release to an inpatient treatment. Mr. Malaro, he is actively violating his bond conditions. So, you know, at this point, how would you like to proceed?
Judge, so I received that show cause notice that Mr. Packard is present in court. We would stand mute as to the allegations and ask that the matter be set out for a pretrial hearing on the issue. And I'd also ask that the underlying matter that's up for today be set out as well. Mr. Packard and I have been in active discussions with respect to getting the matter resolved, but have not yet nailed it down.
All right, so Mr. Packard, I am going to remand you to custody. And I'm going to set this for a pretrial next Wednesday, December 3rd at 8:30 in the morning. I will enter a plea of not guilty on your behalf. I will set bond in the amount of 25,000 cash.
You said how much for the bond?
25,000 cash. So you'd have to post full 25,000. And Miss Adams, can I set this for December 3rd? Is that okay?
Sure,
Or
Judge.
December 2nd? Did you say yes?
The 3rd, yes.
Oh, I was looking at the wrong year. All right. All right, Mr. Packard, I want you to think really long and hard for the next week
Yes, ma'am.
about what you're doing. All right, and you can do the notice of hearing, Mr. Malaro, for the step in order to adjourn. All right.
Yep, thanks, Judge.
All right, so. All right, I got Chad Stewart. Who's the pickup? Oh, it's Trenton Green Blaker. All right. Hi, this is Judge Anselon. Do you have Trenton Jonathan Green Blaker? Is that FLC pickup?
Green Blaker. We do.
Can I see him?
Yeah, that is one.
Yep, that's me.
Okay,
All right, thank you.
thank you.
Bye. Joanne, you gave me this. Thank you, Judge. All right, so Mr. Vila.
Man, Judge, you know these seats get hard.
I'm sorry. I'm so sorry. It was a busy morning. All right. So this is in the matter of the people of the state of Michigan versus Israel Vila. We have two files, 25-22210FH and 25-22368FH. I have, let me see, Mr. Malaro appearing today on both of these files for pre-trial. So, and Isaac Sneed appearing on behalf of the people. I do show Miss Underwood had one file, which is, so do you have both of the files now, Mr. Malaro?
Yes, Your Honor, all files of Mr. Vila belong to me.
Okay, all right. So Mr. Malaro, how would you like to proceed today?
Your Honor, I'd ask to adjourn these matters. I had a conversation with Miss Arnold yesterday. She's the prosecutor assigned to the case. She's actually talking to me about the matter. We're making progress towards resolution. I think probably what we'll do next is between now and our next court date, set a bench conference with the court and see if we can reach a resolution. So that's the basis for my request.
All right. My next available pretrial is January 14 at 8:30 in the morning. Can you do the step in order to adjourn? And Mr. Sneed, can you sign your name with permission?
Hey, Judge, can I ask you?
Hold on, Mr. Vila. Hold on 1 minute. Just give me a minute. Can you do that, Mr. Malaro?
Yeah, I can do the step in orders, Judge. Anything for you.
So Mr. Vila, Mr. Malaro is going to meet with the prosecutor and meet with you. If
listen.
a resolution is reached, no, you listen.
Okay.
Mr. Malaro will call and get you in sooner. And I will see if they'll provide cushions for you next time. But
All right, listen. I'm not worried about no court date. I don't care if the court date's pushed back a year from now. I'm content where I'm at. But I got one question about my bond, right? So I just want to make sure my bond is correct because I've been trying to post it, but they say that my bond is 75,000 cash. And the only thing that you changed was the 25,000. I'm trying to make sure it's only 2,500 that I got to pay because you only changed one bond, and the other bond got raised upstairs 50,000. It was supposed to be a PR bond, and you switched to 25,000. I'm just trying to make sure my bonds is correct because they've been saying 75,000. And I'm trying to get to a rehab while I'm to Dawn Farms while I do all this. I ain't called no tickets in here. I've been trustee. I ain't worried about the court dates, you know. I'm
Okay,
just trying to
okay, so I'm looking. I'm looking at. I have it posted.
Judge, in the ROA, I'm showing on the one ending in 210 is 25,000 and the one ending in 368 is 50,000.
Okay, so it's 25,000 in file number 25-22210. And she's saying it's 50,000 cash surety in file number 25-22368FH.
Right. Now listen, now Angela, when that was the one that was downstairs, and that they had gave me a PR bond on that. I bonded out on the one that you changed, and then they ended up giving my money back because you changed the other bond. So my bond was never changed on the 50,000 because that one was able to go to rehab on that one. You only changed the 25,000. So I'm not understanding why I still not reading. I could go to rehab on the 2522368 case because y'all was only saying I had a bond out on the case I was originally upstairs for, which is 25,000. And I bonded out for the $10,000, and they ended up giving me my money back. Thankfully.
Today, Sam. I've got an Angelo here for you. He says that you're expecting him.
Hold on, I don't know who was talking. Let me see. I'm Becky Adams. The $50,000 bond, was that set up here or down? Okay, hold on.
That was set downstairs.
Hold on, we're looking. So the $50,000 bond was set downstairs.
Right.
Mr. Malaro and Mr. Sneed.
I got paperwork right here.
Did he address my book? No, let's see. All right, so what we did on this one.
Right, that one's 25,000.
All right, from 50. Okay, so Mr. Sneed, it looks like we addressed bond in file number 25-22210FH, which was bound up on a different day, obviously, than the other file. So I did set a $25,000 bond on 25-22210FH when it came upstairs. On file number 25-22368FH, his bond is 50,000 cash surety, and it was obviously bound up in circuit court on a different day, and it looks like bond on that file has not been altered at all. It came up, well, actually yeah. So I think what Mr. Vila is asking is for bond to be reduced from 50 to 25 like it was on the other file. Does that summarize what you said, Mr. Vila?
No. Let me try to clear. If it could get reduced, I'm cool with it. But what I'm saying is when I came back in here on these other cases, they said $50,000, you could go to rehab. But I also had the case with you upstairs, and that bond was $10,000. So I made the $10,000 bond for $1,100. The day that I was supposed to leave to a rehab, y'all called me in court. Y'all raised my bond to $25,000 on that case, and y'all said you was like y'all got to pay the $2,500, which is 10% of the $25,000. In the process, since that court date, I've been trying to do it, but they said since the other case came upstairs, it's not showing that 50,000 was PR bond can go to rehab too. I'm trying to get to a rehab. I'm trying to get to a long-term treatment program.
Are you saying, hold on, are you saying district court gave you a 50,000 PR bond?
A $50,000 cash and surety bond, but able to go to rehab when the bed is available. And the only thing that was holding me up was the 25,000 cash with you. And I paid that. I mean, I paid the $10,000 for 1,000, and then y'all upped it to 25,000. Luckily, the bondsman gave my money back. And in the process, I've been trying to bond out, but it says it's not reading the PR bond upstairs with you, but I got the paperwork right here. Basically, I'm just trying to get it fixed, man, so I could try to at least try to get to a program while I continue to do my time. I'm not worried about the court date.
All right, so it looks like Judge Shaler signed an order on June 3rd of 2025, allowing Mr. Vila to be released to the Salvation Army Harbor Light program. And then, yeah, okay. Mr. Malaro, perhaps you could shed some light.
Well, Judge, as I understood it, there was the district court case. I wasn't involved in it at the beginning, but there was a provision to be released to some rehab, but I think there was and again, I wasn't present for it, an emergency hearing as to his bond. And so one of the bonds, I think, was 25,000 cash or surety. But the other one, as I understood it, did allow for him to be released. And I think that's what Mr. Vilas wants clarified. I mean, obviously, if the court reduces or modifies the bond downward, he's not going to complain about it.
Angela, one more thing.
Mr. Vila, stop talking over people. We've gone through this before. Let Mr. Malaro finish. I know.
The one case that came up from district court, I think Mr. Vila is just seeking clarification that allows him to go to a rehab facility. I think that's his position.
So I will say on file number 25-22210FH, your bond is 25,000 cash surety. So if you post 2,500 to get out. On file number 25-22368FH, and Mr. Sneed, obviously you can weigh in on this. There is an order from Judge Shadler stating that he can be released to Harbor Light on her file, on that file. So I don't think that order has been set aside, Mr. Sneed. So does that order still stand from district court?
Your Honor, I would suspect that when file ending 68FH was bound over to circuit court, that this court's bond conditions take precedent to whatever was previously ordered in district court. Also, with respect to the file ending 10FH, our file indicates that this bond modification to allow the defendant to go to rehab was tabled until there was a discussion with you. That was back in April 23rd. It was then revisited again on May 6th, where the request for bond modification was denied. Then on June 4th, you had continued the bond and set it at 25,000 cash or surety with no conditional release to rehab. Now here we are in November arguing the same thing that's been going on for 7 months. I believe there's a minimum guideline recommendation of 51 months here. So it doesn't stand to reason that Harbor Light is on the table.
It's not Harbor Light.
Or Dawn Farms.
Mr. Malaro?
Well, if someone needs, to treat their addiction, I mean, it's kind of difficult. Mr. Vila is not a person who's prone to running from the police. He doesn't go anywhere. Even if he does, he just stays home. I just think denying him an opportunity to get himself clean. I think, and although Mr. Sneed is correct that there's a guideline determined by the state, but that doesn't mean it's final. And there was some, I think, and I don't want to speak for Miss Arnold, but I thought we had some productive discussion towards resolution yesterday, although to be fair, she still was under a position of some form of MDOC sentence, but it was, I think, a little softened from our conversation. So I don't want to mislead the court since Miss Arnold's not here, but there was some softening of her position from my perspective. And that's the basis for the bench conference.
I think I lost Darren Coast. So, Miss Holly, are you still with us?
Judge, if I recall, Mr. Coast did an assessment, and I think it was not a positive one from our position.
No, I thought Mr. Coast was still with us. So if I remember correctly, so originally the plea offer was that you were going to serve 51 months with Michigan Department of Corrections, Mr. Vila. It sounds like Mr. Malaro is working on and maybe successfully getting that reduced. But because, Mr. Vila, you are looking at a prison term, you know, I'm going to leave the bond as it is.
What about a tether?
Because you have a history of absconding, and if I remember, let me get Mr. Coast. You've left a couple facilities, so hold on.
Oh, the chair.
Mr. Coast, I am on the record on Mr. Vila, Israel Vila's file.
Yes, Judge.
And I know you did an assessment, which I think he maxed out as a high risk for release.
Okay, yeah.
But I also, if I remember correctly, did we arrange for treatment programs for him before?
I would have to look at my notes. Hold on one second here.
Because I remember him leaving programs.
Never left a program. Never.
Okay, hold on. There's something.
Judge, I can tell you exactly what you may be talking about.
Hold on 1 second.
I do have a note back in May, pled guilty to possession of intent to deliver, not to be released from jail to attend treatment. Yeah, I don't see where he was granted that opportunity.
Okay. All right. Okay, thank you. And Miss Holly, thank you. And Miss Holly, are you able to read any notes on his prior compliance? Because I want to say what
I'm looking now. On 2/22/24, his probation was revoked and he did a year jail. That's the last thing. Looks like he was on with Teskey. Failed to appear for VOP sentencing on 3/3/23. Yeah, there was an absconding.
All right.
Harbor Light, he didn't report.
Yeah, I knew there was something. So Mr. Vila, these opportunities have been presented before and you weren't in compliance. And in this situation, you are looking at a prison term. So
I'm not taking no prison. I'm not taking no prison plea. I'm going to trial. I'm not taking.
Okay, it's not up to me, Mr. Vila.
I don't care about no 50 months. I don't care about no time.
I am going to leave your bond as it is. So we're all set. We'll see you back on January 14.
Do me a favor and set the next court date to 2028. What that? Can we do that?
Okay, so. Chad Stewart, thank you for being patient. This is in the matter of people of the state of Michigan versus Chad Landon Stewart, 2 files. 25-22167FH, 25-22168FH. I have Salvatore Malaro appearing on behalf of Mr. Stewart, Isaac Sneed, appearing on behalf of the people. This is a date and time set for a pretrial. Mr. Stewart is testing with Mr. Coast. Continues to do well. He doesn't miss, and he is always completely negative of all substances. Mr. Malaro, how would you like to proceed today?
Your Honor, I have a note in the file that Mr. Stewart was approved for recovery court.
Yeah.
However, I cannot determine from my notes or anything in the file what, if any, plea offer Mr. Stewart could avail himself so that he could enter recovery court.
Mr. Sneed, is there a plea offer that has been made on these files?
Yeah, the plea offer made back in February was that the defendant could plead to possession of methamphetamine in one file, and the people would dismiss the other file. And then if he completes treatment court, then we would dismiss.
Okay, so does it matter which file?
No, thank you, Your Honor.
Okay, so we would say 25-22167. The plea offer is that he would plead guilty to 1 count of possession of methamphetamine, which carries a maximum penalty of up to 10 years in prison. Mr. Stewart, you were in recovery court before, correct? I can't hear you, Mr. Stewart.
Yes, I was.
Yep. And so if you successfully complete it, the charge would be dismissed. Do you understand that?
Yeah, I will complete it.
No. And if you don't complete it, though, you'll have a 10-year possession of methamphetamine charge on your record.
Okay.
Mr. Malaro, is that the plea offer as you understand it?
It is now, Judge. I mean, this case been
Mr.
around
Stewart,
for a while. So.
do you wish to avail yourself of the plea?
Yes.
Okay. Do you need to talk to Mr. Malaro?
I guess it doesn't matter.
Okay, let me open a breakout room just to give you a chance to talk to Mr. Malaro.
Okay.
And I will. So you must be Trenton Jonathan Green Blaker.
Yes, ma'am.
All right, this is in the matter of Chelsea Lynn Blaker versus Trenton Jonathan Green Blaker, file number 2018-45596DM. This is, looks like, this is a Judge Olsaver file, and I'm handling that for him today. So, Mr. Blaker, Green Blaker, we're here on 2 things today. One, you have a monthly charge for child support in the amount of $1,012. As of today's date, you have an arrearage of $50,480.72. Has he had a felony charge for this, Ms. Senkowitz?
Yes, Your Honor, back in 2023.
Okay, is it active? Hold on, what'd you say, Mr. Green Blaker?
My nerves, I was just trying to speak for a minute, but my nerves are really high right now, but can I speak?
No. So, Mr. Green, I gotta go through your rights, Mr. Green Blaker.
Okay.
So, is he off probation now, Ms. Senkowitz? Or is he?
I
I'm just
believe so,
wondering,
Your
you
Honor.
can be recharged over and over and over, Mr. Green Blaker. So I'm just waiting, I'm asking because I want to see if they charged you again.
It looks like he pled guilty and was given a 1-year suspended jail sentence at that time, so.
Okay, all right, Mr. Green Blaker, don't talk when other people are talking. All right, so Mr. Green Blaker, do you understand that the Attorney General can also charge you again with failure to pay child support? Okay, now this, I would say this is not your first contempt, this is like your 6th. And then, so failure to pay child support can carry a maximum penalty of up to 90 days in jail. And I show that the last payment we received was $50.22. back on August 15 of 2022. And you were ordered, would you stop talking over me, or I'm gonna see you again on Monday? Because I'm gonna think you're under the influence of something and not able to control yourself. So stop talking.
Okay.
Okay, so, contempt and let's see, failure to appear. It looks like there was a failure to appear for November 24 of 2025. So a bench warrant was issued, and that carries a maximum penalty of up to 90 days in jail. So, in 2023, you've made 5 payments since you were placed on felony. You got that 1-year suspended jail term, totaling $175. And so, Mr. Green Blaker, you have a right to have an attorney represent you here today on all subsequent contempt of court proceedings. Would you like an attorney appointed to represent you?
Yes, Your Honor.
Okay, so I am going to put you in a breakout room with Rhonda Underwood to talk about this. Miss Underwood, you did receive the paperwork.
I did.
Excellent. So I'm gonna pop you in that waiting room. Go ahead and join that breakout room. All right, Mr. Malaro and Chad Stewart. You're muted, Mr. Malaro. I don't know, he's talking to somebody other than me. You can tell he's Italian. He's like waving that hand around like a flag. Oh, I think he heard me. Yeah, I'm talking to you, Mr. Malaro. You're muted. Can't hear a thing you're saying. Hi, Mr. Malaro.
Hey, Judge.
Are you ready?
Yes, Judge, he wasn't in the breakout, and so we just did a phone call.
Sorry, I opened the breakout room, I thought. Okay.
Yeah, I'm sure you did. It just, some of us are not as technologically advanced as others.
So, Mr. Stewart, have you had enough time to talk to your attorney now?
Yeah.
Okay, Mr. Malaro, is he going to avail himself of the plea offer?
He is, Your Honor.
All right, Mr. Stewart, want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Now, Mr. Stewart, I recited the plea offer after Mr. Sneed made it on the record. So you've heard the statement and the discussion we had. Is it your intention on file number 25-22167FH to plead guilty to count 1, controlled substance, possession of methamphetamine, which carries a maximum penalty of up to 10 years in prison? Your habitual offender 4th offense notice would be dismissed at the time of sentencing. All charges in file number 25-2216FH will be dismissed at the time of sentencing. And if you successfully complete the recovery court program, then this charge would actually be dismissed. So is it your intention then to plead guilty to that count?
Yes.
Okay, so speak up loud and repeat that again, Mr. Stewart.
Yes, it is.
All right, excellent. So are you satisfied with Mr. Malaro and the advice that he has given you?
I am.
All right, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Malaro?
Yes, Judge, that's correct.
Mr. Sneed?
Yes, Your Honor.
And is that correct as far as you are aware, Mr. Stewart?
Yeah.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial you have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
Do you understand if your plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding, failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Mr. Stewart?
No, ma'am.
All right. How do you wish to plead to the charge that on or about September 29 of 2024 in the city of Adrian in the county of Lenawee that you did commit the offense, controlled substance, possession of methamphetamine, guilty or not guilty?
Guilty.
Has anyone made any threats or promises to induce you to plead guilty to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro?
No, Your Honor.
Mr. Sneen?
No, Your Honor.
Other than the agreement that was placed on the record, Mr. Stewart, has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
Right?
Well, Judge, other than the plea offer, yes.
Other than the plea offer, yep. Is it your own choice to plead guilty, Mr. Stewart?
Yes.
So, Mr. Stewart, on September 29 of 2024, were you in the city of Adrian in the county of Lenawee?
Yeah.
And did you have in your possession methamphetamine?
I did.
Did you know it was methamphetamine?
Yeah.
Did you have any legal right to possess the methamphetamine?
No.
Okay. All right, are you satisfied, Mr. Sneen?
I am. Thanks, Judge.
All right, has the court complied with the MCR 6.302 B, C, and D? Mr. Malaro?
I believe the court has.
Mr. Sneen?
Yes, thank you.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence. I'm so sorry. In this case, with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the agreement that was placed on the record, I'm going to refer this matter to the probation department for a pre-sentence investigation. I'm going to set this for sentencing on, what day did I say? January 9 at 8:15 in the morning. And Mr. Stewart, do you still have Sarah Teskey's phone number?
I don't think I have it still.
Okay, well, I'm gonna put you in a breakout room with Miss Holly real quick. She's gonna get your address, your personal information. You're going to continue to test with Mr. Coast
Okay.
unless Ms. Teskey has other requirements, so work with Ms. Teskey and on that, and Ms. Holly, he was in recovery court before, so if you could give him Ms. Teskey's work cell phone number, because he'll need to contact her we start them early now, so as a bond condition. And when you meet with Ms. Holly, she's gonna tell you how to go through the PSI process. Make sure you show up for that interview and comply with anything, be truthful about your background, the events that occurred. And we will see you back for sentencing on January 9 at 8:15 in the morning. Do you wish to appear in person or via Zoom for sentencing?
Zoom.
All right, and Mr. Malaro, anything else?
No, Your Honor, thank you.
All right, so Mr. Stewart, although I'm sad to see you back, I am glad that you want to join the recovery court program again. So Mr. Stewart, Ms. Holly, I'm going to open up the breakout room. Ms. Holly, I believe that's our last criminal matter today.
Okay, thank you.
All right, so you can both disconnect when you're all set. Thank you.
Thank you, Judge.
I don't
Have a
know
nice
what to offer
Thanksgiving.
emergencies.
Everybody eat lots of turkey.
You too. Bye.
Petrozzini.
All right. Mr. Stewart, did you get the invitation to join there? Did you get the invitation to join the break? Yep, he did. Okay, he's in. All right, so Ms. Underwood, we are back. Hold on, let me write this down. Complete record. All right. So Ms. Underwood, have you had an opportunity to speak with Mr. Green Blaker?
I have, Your Honor.
Mr. Green Blaker,
Your Honor, was.
Hold on. I was telling him to hold on. He raised his hand and was trying to talk, and you're talking right now. Go ahead, Ms. Underwood.
Court to enter a not guilty plea on Mr. Green Blaker's behalf. Mr. Green Blaker was taken into custody at the courthouse, Your Honor, where he himself presented himself at the front of the court to request a hearing on a reduction and visitation arrangements, Your Honor. Mr. Green Blaker is in no way trying to avoid the court. He also disputes that there have not been payments made. I believe he worked at rallies for a while and PSEP payments were taken out. Mr. Green Blaker is currently employed at Superior Landscaping, where he is supposed to be working today, Your Honor. I would request, in view of the fact that Mr. Green Blaker himself came to the courthouse, that the court consider a PR bond in this matter and set it for 2 weeks down the road with Judge Olsaver. And we see where Mr. Green Blaker is at that point as far as both getting payments, Your Honor, and getting a hearing scheduled before the referee.
So, Mr. Green Blaker, anything you say could be used against you. So you have an attorney. So control yourself and just wait a minute. Ms. Sinkowitz, how many payments have we received in 2025?
I don't.
In 2025, Your Honor, just the one in May
For $400.
for $50.22.
Oh, I
Had that for
Okay.
hold on, I show August 15 of 25. Is
I'm
that
sorry,
August or May?
August. I'm sorry, it was August. I apologize, Your Honor.
All right, so Miss Underwood, the only payment we received in 2025 was $50.22 in August.
Mr.
Do you have
Green Blaker, I
other
believe, would
children,
dispute
Mr.
those
Green Blaker?
numbers.
No, ma'am, with these three, and the parent has said that she's received payment, so I know there's a misunderstanding. I just had these kids we just got the order straightened up, and I had the kids last weekend for the new order, because I filed the referee hearing. And this is like, I'm literally trying to get everything back. I know it don't look like it, but I made a payment of $400 in May. That was when my dad passed away. He left me a little.
Okay,
bit, so
stop
I made
talking for a
personal
minute.
payment.
Stop talking. Hold on. Ms. Sinkowitz, do we show a payment of 400 in May?
Your Honor, I can check with accounting. I'm not seeing it. Let me double check. Maybe I overlooked it. Hold on one moment, please.
Yep.
I have the receipt at home.
Well, just
Let me look.
hold on. Give us a minute.
My apologies, Your Honor. Yes, there was a $400 payment made in May. Yes.
Okay, but the
I
last
did overlook
payment was
that. I
50
apologize.
bucks. Yep, no, and the last payment
August,
was
yes.
$50 in August 15th.
Yes.
So Mr. Greenblaker, are you saying you made other payments than that?
Yes, Your Honor, for sure. I know that she got one at my last week at Beijing, the company here in Asia, before I moved to Superior. I don't know why the payments haven't come out for here
Mr.
yet.
Greenblaker, when was the last payment that was made?
The last payment that came out would have been from Beijing, would have been August of 2025.
Okay, several
And that
months
was
ago.
the
So I don't know if
$50.22 payment.
Yes, but ma'am, I've been working since then, and I don't know why they're not being garnished. I've been consecutively working, like this is
So,
as long
all
as I've been
right,
working.
let's stop. So what I will say is, Ms. Underwood, I'm more than happy to enter a plea of not guilty on behalf of your client. But Mr. Greenblaker, common sense would say if it ain't coming out of your check, you gotta make the payment. So, you know,
That's why I've been doing.
no, I'm
that's why I've been
talking now.
courthouse so much.
So Miss Underwood, I'm not going to set them out on a PR bond. I will set a $1,500 bond. But he
Your Honor,
is
he
not
came in
making.
himself yesterday.
Ma'am, I have
Well, good.
He literally
Mr.
came in
Greenblaker,
himself.
I feel like
No,
you
just
are
tell me what I
struggling to
have.
control yourself today. And there is
I was trying
one
to tell you
thing. No.
I was trying to tell you
So
how much
Miss
money I had
Underwood,
to check
I
today.
will enter a plea of not guilty, but I'm gonna set bond at $1,500. He didn't turn himself in. He came to schedule a referee hearing. Is that what you're saying? That's what you said, Miss Underwood.
Your
So
Honor.
I will enter a PR, I will enter a not guilty plea, but I'm gonna set bond in the amount of $1,500.
Cash, Judge?
Cash. And that would be payable either at the jail or at the courthouse to get him released. Miss Adams, do you know if Judge Olsaver, or Miss Senkowitz, do you know if Judge Olsaver has Monday FOC show causes?
We do Monday at 8. Yes, yeah.
And I'll set this for a pretrial, well, a pretrial in front of Judge Olsaver on December 1 at, what time does he do them, Miss Senkowitz?
8 a.m.
At 8 a.m. So if you postpone, you still gotta come. If you post the money that gets paid in front of the court, you still have to show up in front of Judge Olsaver on Monday at 8 o'clock, all right? But I set your bond at $1,500, and that's payable to the front of the court or at the jail, all right?
Yep.
All right, thank you.
I believe that's my
Underwood.
docket for the day.
I believe that's everything. Thank you for your patience this morning, Miss Underwood. All
Thank
right,
you, Your Honor.
thanks, Miss Senkowitz.
Happy Thanksgiving.
You too. All right, so usually when I have attorneys in both courts, it goes faster. But obviously when I have everybody, it doesn't go faster. Plus I had chatty people this morning. So I'm gonna take a break because I haven't got off the bench since like 8. And then I'll be back in 5 minutes. Less probably. Miss Fade.
Thank you, Judge.
Please rise. Circuit Court's now in session. Be seated.
All right, this is in the matter of Scott Thompson versus Andrea Thompson, file number 2016-43236 DM.